mention. My lord, may I be permitted to mention one matter?
May I please invest?
Yes, hold on. There is some mention
Yes, my lord.
to VC. Yes,
I will do item number 46, my lord.
just hold on, please.
My lord, the
Yes,
matter,
ma'am. Yes,
my lordship, my lord, the matter was before your lordships, my lord, on 16th of, am I audible, my lord?
yes.
My lord, the matter before your lordships, my lord, on 16th of February, my lord, and it was regarding a Mizoram matter, a notification by which appeal has been filed before your lordships, my lord. The notification was before the single judge's bench. A notification by the single judge was being
Ma'am,
squashed.
we are not able to make out what you are trying to convey.
Am I audible now, my lord?
Right. Yes,
My lord, am I audible? My lord,
Yes.
my lord, this is regarding
so
a
what she wants now? You want a listing of the matter?
my lord, because my lord also directed the extension of the interim order, but by maybe there is a misprint. The interim order has not been extended, your lordship. My lord, kindly list the matter tomorrow, if my lord so pleases, my lord, so that I can be before my lords physically, your lordship. At the
When
first
do you want the matter to be listed?
tomorrow,
Can you
your lord.
tell us the date?
Tomorrow, my lord. Tomorrow,
Tomorrow is 23rd, no?
my
Very
lord.
well.
Tomorrow at the
Let it
first,
come up tomorrow.
at the first of the court, your lordship.
We'll have it tomorrow, ma'am.
Deeply obliged, my lord. Deeply.
May I please, your lord? My lord, I beg to mention item number 46, my lord.
Yeah.
Today, yes, my lord. It will be done for 2 weeks, my lord.
Sir, we have given an instruction that if you want an adjournment,
My lord.
please convey in advance. There is a.
Yes, I have, yes, yesterday I was.
You have done,
Yes.
it?
Yes.
Not noted. All right. 43, you were saying.
46, my lord.
What is he doing? And counsel for the appellant has circulated an adjournment thing. The other side has no objection. List after
2 weeks, my lord.
2 weeks. This is an appeal from what judgment?
Meta
Judgment of
from the family court. Right?
family court. Are you sure?
Yes, my lord.
Not from the district court?
No, my lord. Obligement.
May I please, I beg to mention item 47, I have already submitted yesterday.
Same order.
Obliged.
Lordship, I beg to mention item number 48. I have already submitted the adjournment request.
Very well. Same order.
Obliged.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 39, lordship. I have already submitted, lordship.
very well. 4 weeks.
Lordship. May I please, your lordship? I beg to mention item number 11 and 12, my lord. I have already submitted, my lord.
11, 12.
Yes, my lord.
Okay. 4 weeks.
My lord. Highly obliged.
May I please your lordship? Lordship, I beg to mention item number 44. I have already submitted lordship. The
4
adjournments.
weeks. You have submitted what, madam?
The adjournments.
Is it?
May it please your lordship, I beg to mention item number 41, and I have already submitted the adjournment.
Very well. 4 weeks.
Thank you.
May it please, my lords, I beg to mention item number 18 to 34. There is a series, my lord, along with item 35, my lord. I have already submitted an adjournment application.
Sir,
my lord.
why do you want to get this bunch adjourned? You would like to know.
My lord, these are very old matters which have been handled by the prior set of standing counsel for the APDCL, my lord. After we were engaged, these briefs are not passed over to us, my lord. Therefore, we need some time to reconstruct and prepare for it, my lord.
Okay. Then counsel for the land counsel Shri so and so, who has now been engaged on behalf of the APDC, submits that he requires some time to reconstruct the brief. He has circulated an adjournment slip. Re-notify. Put a date on these matters. 21st March.
I'm obliged, my lord.
May I please, your lord?
35 also tagged with the same matter.
May I
Is
please,
this
your lord?
common matter? Common
Yes, my lord.
35.
May I please, your lordship? My lord, I beg to mention item number 43.
Yes.
My lord, we are directed to furnish, my lord, report from the postal official, my lord.
Hmm.
But my lord,
Unfortunately, my lord, we are unable to collect the.
Do you want to
report.
take fresh steps?
No, my lord, we'll go to the website, official, to collect the report, my lord. If it is
And
possible, my
counsel
lord.
for the appellant placed for and is granted a week's time to place on record proof of service. 2 weeks.
Republish, my lord.
May it please your lordship, I'd like to mention item number 63. I've already submitted the adjournment.
53,
63
63.
hearing.
Counsel to the appellant has circulated an adjournment slip, list of 4 weeks.
Much up.
Item number 1 of daily list for motion.
May it please your lordship. May it please your lordship. Lordship, petitioner before your lordship, an event of remote area lordship, and he is praying on behalf of the 4 villagers lordship. The PIL is in
You
file.
have submitted a representation to the deputy
Lordship,
commissioner.
lordship,
He will direct that the representation would be objectively considered.
lordship, page number 27, lordship.
It has already been considered.
Lordship, inquiry has not been made, lordship. It
So
till
we
date.
will direct the deputy commissioner
Lordship,
to hold the inquiry,
lordship,
pass and reason order.
lordship.
The instructed petition in the nature of PIL has been filed by the petitioner's hearing with the following prayers. It is submitted that before approaching the court, the petitioner submitted detailed representation to the deputy commissioner, Udalgiri district, Udalgiri, annexure 1, for ventilating the grievances. However, as per the petitioner's despite the direction given by the deputy commissioner, the requisite inquiry has not been made. In view of the submissions noted above, we hereby direct the deputy commissioner, Udalgiri district, Udalgiri, to objectively consider the representation of the petitioners / get an inquiry made into the grievances raised therein and decide the representation by a speaking order / take appropriate steps if so required as per law. Whereupon requisite exercise in this regard shall be completed within 3 months. In case any adverse orders are passed, the petitioner shall be at liberty to file fresh writ petition. The instant writ petition is disposed of with the above direction.
Deeply approved.
Item number 2 to 4 for admission.
May I please come? My lord, the petitioners before my lord are LP school teachers. My lord, they are agreed by the reduction in their pay scale, which after the pay commission recommendation we
I
accept.
suggest you to have a look at these this judgment from Rajasthan High Court
Lordship,
and the consequential orders. The government advocate would also like to have a look at
sure,
identical controversy.
lordship,
There was a notification dated 30th October 2017,
lordship,
whereby on account of revision of pay scales, the salary of certain set of employees was reduced
lordship,
and recoveries were directed.
lordship,
This is the direction which has been given. So if the government council can take instructions, we'll pass it over,
lordship.
exchange the, you taken out only one thing.
My lord, we'll have it. We'll do the.
We'll just have a look at it. Maybe that is the.
Recovery আমার এখানে নাই। Recovery
Judgment नहीं देगा मेरे revisit examine. You have a look at it, we'll pass it over.
Lordship,
And you let us know.
lordship,
If this is acceptable, we can decide it in the same manner.
lordship. My lord is having it today itself, my lord?
No.
In that case, my lord, I will have to see instruction from the government.
Government council, we have to seek instruction.
My lord will have a convenient date then. Any date.
Then government council, praise for it is granted. How much time do you need?
Lots, 7 days, my lord, next week.
A week's time to complete his instruction. Re-notify on 2nd March.
Lordship,
My lord.
Yes. What do you? What did you?
Matter number 5,
Five, counsel for the petitioner appellant has circulated an entitlement slip list of 4 weeks.
matter number 6,
Please, lordships. My lord, my senior is on legs in court in the true. Kindly pass over the matter for time being.
For 1 week,
For time being.
for the time being.
Yes, my lord.
Lordship, in this matter.
Paso.
May it please your lordship. Here, your lordship, state was directed to file an affidavit, your lordship. We have received the instruction. So your lordship, from 1 week time, may can
We will make certain queries from the appellant's counsel. Let us have it in second now.
Yes.
matter number 7,
May it please your lordship. Lordship, in this petition, we the petitioners have availed financial assistance from the respondents in the form of a term loan and a housing loan, lordship. Thereafter, it was coupled into a few top-up loans. But lordship, after the COVID-19 struck down, what happened was we were unable to obtain the moratorium because we were informed that it will be automatically credited to us. But still the EMIs were being deducted. Thereafter, lordship, what happened? The Honorable Apex Court had passed an interim order stating that from loan accounts which will not be NPA from 31 August 2020 shall not be declared NPA. When our loan accounts were not declared NPA till that particular period of time. But lordship, after 31/1/2021, we were declared NPA, lordship. So thereafter, we were not unable to even obtain the restructuring scheme, which was a notification provided by the
That
Reserve.
remedy lies in the DRT Act.
Lordship, it does, but
Remedy, authorized officer, State Bank, Travancore.
lordship, it
Why
does,
a petition is to be entertained, sir?
because lordship, the respondents are controlling public money, lordship, and who are regulated by the Reserve Bank of India, lordship. So considering that there is a contravention of the order of the Honorable Apex Court, lordship.
No, there is no contravention. They waited for that statutory period of extension of limitation.
But lordship, that did
Only
not,
thereafter they have acted.
no, lordship, they did not follow that, lordship. Because as per the
You
Honorable,
can demonstrate that to the DRT tribunal. Why
lordship,
not? You can demonstrate that by approaching the statutory body.
lordship,
Go and file approved application in the DRT tribunal. We'll extend the limitation if you want to approach.
lordship. MK Das, lordship.
After going to
Section 17, your lord. Section 17 of surface here.
Obliged, lordship.
matter number 8,
This case, my lord, no affidavit has been
My lord,
filed by the.
We have sent the affidavit of waiting, well, some minor suggestions were made. We have sent it back for corrections, matter. I require 2 weeks time.
But you want to file affidavit?
My lord, yes, because the manner in which the 2018 recruitment rules had been amended, what was the past history and what everything, my lord, it just need to begin on record.
Here partly led by with secondary is what it is that then
All right.
there are a lot of
Item number 9,
Please, your lordship, on the last occasion, this appeal is against me, against GTC. Again, on the last occasion, I had informed the honorable court that insolvency proceeding was pending and I was asked to file an affidavit, putting that on record. I have put then on record that insolvency proceeding has already started. And view of this, section 14 will come into operation of the IBC. So obviously, this proceedings would have to be stayed.
Lordship, I have received the copy. Under section 14, Lordship, no proceeding can proceed unless moratorium is declared. Interestingly, on 9/2/2023, between the same respondent, another proceeding was there, but no plea was taken before the Supreme Court actually. Although the appeal was.
Matter. In
No.
this case, the plea, it is correct.
Here it is taken, but in Supreme Court it was not taken.
Then we will have to go by the mandate of law.
No, that is correct. I'm just pointing out. Lordship. It was on 9/2/2023.
But that was by GTC. So,
That was by the
against-
Golden Tobacco against the Central Excise.
so that is a different matter.
Even then, Lordship, in my submission, they could have taken this plea before, and that appeal was dismissed along with the first judge. Just for reference,
That doesn't change the position.
no, Lordship,
Proceedings have been initiated, that's a fact.
no, I'm not denying that. Lord. I'm just making a reference to that because on 9th of February, this thing happened. Lord.
No, say, right.
So, 14 of the
Bankruptcy, insolvency and bankruptcy code,
Bankruptcy Code 2016.
2016.
In view of we direct that further proceeding.
Obliged.
Should we close it?
You can close the petition.
Lordship,
Ultimately, the decision of the
no, Lordship, the
Yes.
proceeding will be stayed, Lordship, subject to the outcome of the proceeding pending before the.
Because
Lordship, then we will
the
be left,
decision of corporate resolution, that will be
Yes.
final ultimately.
yes, that will be final, Lord.
So then why do we need to sustain this?
Lordship, regarding our claim, Lordship,
whatever they have to lodge before the insolvency resolution professional.
no, 10 number. No, Lordship, this is with regard to item 10, Lord. This is with regard to item 10.
Obliged.
item number 10,
So this is appeal by the revenue against the order dated 21/6/2022, whereby the tribunal held that the revenue received that not be calculated as income. Besides that, Lordship, there was some valuation that was also reversed by the appellate tribunal as well as by the CAP appeal lot. Much.
Item number 13.
Is there after 10 years?
Lordship.
Item number 14.
May I speak, Your Worship? My lord, this appeal is directed against the judgment order dated 6/3/2019, passed by the learned single judge, my lord. Your Lordship will find the order at page 56. Page 56, my lord. And the relevant portion, Your Lordship, will come at page. Just a minute. Why are you agreeing to this order? My lord, because the learned single judge has not considered that the impact of section 20 of the Act, my lord, 1960, rights of personal with disabilities Act 2016, and secondly, section 22 and 33 of the persons with disabilities, my lord, which has been repealed by the instant case, my lord. My lord, first of all, may I take your lordship to section 32 of the persons with disabilities, my lord, 95. And specifically section 32 and 33, my lord.
This is in relation to reservation.
Yes, it relates to the reservation because I have been appointed in 1994, my lord. And will issue notice. Who is appearing to the state? Learned. And Mr. Matul.
Item number 15.
May it please your lordship. My lord, this is against rejection of a primary challenge. My lord.
May I please? I may pay for passover of the matter for the day of. May come upon which allows your lord on Monday.
Was it the real issue? What has been decided?
My lord, that is the only issue, my lord, whether a retired bank manager
Will be a
could be
public,
termed as a public servant. Whether he's competent.
how much time? 1 week,
It's one.
but Mr. Not. But Mr.
For you.
Praise God. 1 week.
Number 16.
Everybody tonight?
No.
Can I go? May it please your lordship. My lord, we are aggrieved by the order whereby the learned single judge has held that the writ petition has become infructuous. That is not correct, my lord. In fact, the matter went to Supreme Court. Even Supreme Court SLP has dismissed. That means the interim order of the learned single judge revived. If the logs are not available, I am entitled to the value. So therefore, to that extent, my lord, if the seizure was good, that's a different issue. If the seizure is bad, in that case, I am entitled to the value. So, my lord, that adjudication has to be done by the learned single judge, my lord. So my humble submission is,
The
my lord.
incident is of 1999.
Oh, yes, my lord, because the matter was pending in Supreme Court.
Logs are not available.
Till 2017, matter was pending before the Honorable Supreme Court. No, logs were sold by the Hyper Committee.
Despite the stay order of this court.
That's what the stay order of the Honorable, which was observed by the Honorable Supreme Court. So, my lord, my only humble submission is since private parties.
That was brought to the notice of the single bench.
Yes, my lord.
Is
It was- it
the relevant part of the order.
Yeah, the learned order is at page 89, my lord. If your lordship would kindly come to page 92, my lord. Para 7. This interim order could not be pursued due to the civil appeal number so and so filed by the state before the Honorable Supreme Court, in which status quo was issued. The civil appeal was subsequently dismissed by the Honorable Supreme Court on 21/7/17. Thereafter, petitioner, now represented by his son, submitted a letter to the Environment and Forest and Climate Conservation Department for release of 45% of the Gomari log, which according to him was kept at the Bhairavi railway yard. The petitioner was then informed that there was no Gomari log lying in the Bhairavi railway station yard. The petitioner is informed to show the concerned officials of so-and-so the exact location of so-and-so. My lord, since
The original challenge was to the seizure.
season.
So we have to examine whether the seizure was valid or not.
Yes,
And if not, then the value of the log has to be.
yes, that is what. I think, my lord, since no private parties are involved, Constitution pass that order, my lord. State is of course represented.
And we'll have to remand the matter to the single bench.
Precisely.
Well, I just
Precisely.
want to point out one thing
Yes.
before your lordship, my lord. My lord, the prayer which was made in the writ petition initially, kindly see the prayer.
Page number.
Prayer is at page 36. There's a writ petition which was structured at that relevant time in 99. Kindly see the prayer, my lord. Why this petition should not be allowed after hearing both the parties make the rule absolute and issue direction to respondent to release the Gomari logs of the writ petitioner from detention and return the transit pass to the writ petitioner. Now there are.
Technically, sir, ultimately it is, they are challenging
No,
your seizure proceeding.
I'm just.
Let us see the ground.
It has been confiscated, my lord. Subsequently, there was a high power committee, as your lordship, there's a Supreme Court high power.
Which is the confiscation order?
The confiscation order, my lord, it has been, that's, I think it's not been annexed here.
So, yes, that would be an issue. The
My lord, what
confiscation
I-
order is not being challenged.
No, that's what I want. What I'm saying, no, my lord will kindly see one, if your lordship kindly see at 96, page 96, my lord.
Yes.
96 order.
Confiscation did not take
Kindly
place.
say 96, 22/7, 2022. This is the same council who said, my lord, the learned can submit the seized log were disposed of, pendency return when the status code are issued by the learned company, however, submit the matter has become infructuous, may be allowed to withdraw the same. Now thereafter, he files a review application at page 97. Now 97, kindly see
Sir, can you point out the confiscation order?
that I have to look into.
no,
I have,
Just let us know
right.
whether there is a confiscation order, and if so, there is a remedy.
Yes,
against that
sir.
order.
Yes,
Statutory
correct.
remedy.
My lord, kindly see for a moment, I am troubling on page 94, my lord.
Yes.
94 para 9, kindly see. Para 9. The learned counsel petitioner does submit the instant reply in the present form and style is now infructuous and therefore may be closed. He has, however, prayed that he may be allowed to file a fresh petition for regressal of his grievance. Now 10 is the counsel for the government. Since the LSC's Gamari log were not longer found in Barbary railway yard, has become infirm further in the instant only the state government has been made a party. While the state government only is not wholly responsible for any state steps Alice to have taken with respect to Alice, sees Gamari law. So as there was, my lord, the order, the submission of the petition, the government advocate. So para 11 is a finding. However, having heard the learned counsel both the parties, this court finds that since the mentioned Gamari law, Alice to be seized numbering 517 numbers by the respondent kept in the Barbary railway yard are no longer found the safe place. This instant delay is for the release of Gamari log numbering so and so for transfer outside the state of Mizoram.
Sir, that is, there is an order of confiscation.
Yes.
Where is the question of release?
No, what I am saying, I understand. But what it is the way within the structure, the writ petition, my lord.
Was
And once-
only for a prayer of release.
Yes,
That's all.
my lord, once the prayer is made by learned counsel, I don't want to press it. But there is, of course, another remedy, my lord. That's the reason why, my
We'll
lord.
have a look at the confiscation order.
Yes, I will just, my lord, it is not annexed here, it, my lord. The configuration. order.
That is in your record.
Yes, I will just say.
Sorry, but please bring
Yes.
from. Counsel for the, then counsel for foreign state of. Shall place on record the order whereby the seized log for confiscation. Based on. Then would you be able to send that up?
That's from the Mizoram, my lord. I'll ask them. I'll ask them
From the
because
email,
I'm,
sir.
I'm just going tomorrow itself to ask definitely.
Let it be on second, my lord.
The state went before the Supreme Court.
Yes.
Which order?
State
Against
went-
the stay
my
order.
lord, no, there was an interim order which was passed by the learned single judge. The learned single has said 44,
Five,
now
five.
45 number of Gamari logs,
45%.
45%. So that maybe it's a private, so you release it. So the state went before the apex court and there was initially a stay order. The subsequently a status quo order was passed. Before the apex court, my lord, it was entire high power committee has sold the entire. So now there was a contempt, but the Supreme Court said the matter has become infructuous now. So the matter, they came up before the learned single judge because the matter was pending.
45%. We want to see the confiscation order. If anything has been saved,
Yes.
because 45% are beyond the purview of the confiscation order, then yes, they have a case.
Well, if I succeed in the writ petition, I'll be entitled to the value. That adjudication has not been extended.
Only if you are able to satisfy the court
Yes.
that the confiscation, the
Order is bad.
seeking the return, they are beyond the confiscation order.
Yes.
But
Because confiscation order not being in challenge.
Correct.
they
nothing would
filed an
survive.
affidavit, they filed an affidavit of magistrate and saying the council itself, yeah, we did not make this statement before the learned single judge para 9.
Very good.
They could have gone for review of this order, my lord. Anyhow, my lord.
List on,
My lord, 2nd of March,
we'll have it on 14th March.
my lord, that week, lordship, there's a matter in Supreme Court Constitution bench, my lord. Or lordship will have it little later, my lord.
Later, we'll have it beyond that,
Yes.
22nd March.
Yes.
Deeply.
Deeply.
Item number 17 for order.
There is a mention.
Also, we had moved in a for adjournment.
Concept to the petitioner calculated and adjournment slip placed after 4 weeks. Same order in 1890. That we have already posted on 21st March.
Item number 36.
May I please your lordship, my lord, I have taken fresh steps upon the private respondent lordship as per order of this honorable court. Lordship.
What about the order dated 8th February?
8th February, my lord, that specific allegation that I have to make, lordship. Lordship, that specific allegation already in my petition, lordship. Lordship,
You made a representation to anyone before?
yes,
approaching the court?
yes, lordship. I have already made a representation that inquiry was going to be held, but that was not done, lordship, as per direction of the commissioner, lord. That page 44, lordship, there is a direction from the commissioner to hold an inquiry, lordship.
Page 44, where is your representation?
Lordship, my representation, lordship, there are so many representations, lordship. At page 34, lordship, which was submitted to the honorable chief minister, lordship.
Marketing of president and secretary of study. It appears that. How many petitioners here?
It is only one petitioner, lord.
Petitioner that are just submitted a representation. 27 cents of. No action. And up going to met by entertaining to the inquiry. I but deputy commissioner be make that correct. But by that's why it is for directly consider the grievance of the calculated and dispose of the same by speaking. If the petitioner continues, then next week will be back to do it. Yes, sir.
Hello, blood.
Item number 37.
Matthew, Your Lordship. I'm very sorry, Your Lordship. In this case, file has been misplaced, Your Lordship. But one thing is that, Your Lordship, the thing is that another similar matter is pending before this honorable court, and in this case, a high power committee was constituted by this honorable court. The report has been submitted before the honorable court. So this
No, my lord,
matter-
no, this is totally different. He's
No, Your
traversing the different, my lord, different way, totally different, my lord. This is different. This is, my lord, he alleged that mining, illegal mining is going on, certain permits were assailed, my lord. We have filed an affidavit saying that these are government permits, my lord. We have a rule.
Yes, Your Lordship.
But that is totally different, my lord.
Our petition, our prayer is that the tender was given in the name of Hekunala, and the stone was collected from the river bed, Mudra bed, Your Lordship.
That is not his case, my lord.
Yes, Your Lordship. So
Typically,
either one date may be given, Your Lordship, so I can.
You want to find the rejoinder as here?
no, my lord.
No, Your Lordship.
His prayer is totally different. He's resorting to another PIL, my lord.
Matter number 38.
My lord, water project matter, my lord, in Karbi Anglong district, my lord. In fact, state has filed affidavit on 28th, my lord. They are saying that because of fund.
Where is the learned advocate in it?
My lord, the learned advocate. My lord, the learned advocate general is out of station, my lord.
Station only or out of?
Yes.
But what is to be done? We can't wait.
My lord, the Karbi Anglong department has filed an affidavit, my lord, yesterday, my lord. The Karbi Anglong, my lord, Autonomous Council has
What
filed
has
an
happened to the fund? The last order reflects that there was an attempt.
Yes, my lord.
Figure out if some additional funds can be made available to complete
For
the project.
drinking water purposes, the government has to come out money.
Yes, my lord.
There's no question of escaping these expenses.
My lord, maybe please take up this matter on Tuesday, my lord. Because the learned advocate general is happy. I just go.
This before, this one, before a bench of both of us at 4:15 p.m. Four o'clock, 4 p.m.
Item number 40.
My lord, here in this case, my lord, lordship may kindly have a look at the order dated 39/2022, where my lord, the mathematical model study report from Guwahati IIT is required to place before this honorable court. My friend, my lord, Goswami was I think collected the report, my lord. That should be placed before our honor, my lord.
Yes. The government has got this report from the IIT. We can place.
This is the. They would be filing it.
IIT report is there.
Place it on record,
My by way of affidavit.
providing a copy to the petitioner's counsel.
My lord. I'm referring for 6 to 9.
Report from the IIT. 6 weeks that is. At the met.
My lordship, a matter will come up, my lord,
Up to week.
after 2 weeks.
Deeply obliged, lordship.
Item number 42.
May I please, Your Lordship? In this case, Your Lordship, affidavit has been filed, Your Lordship. May I please, Your Lordship? In this case, Your Lordship, affidavit has been filed, Your Lordship, and we have filed our counsel reply to the, Your Lordship. It can be taken up for disposal, Your Lordship. Only I am praying accommodation for today, Your Lordship. If it is not inconvenient for Your Lordship. I could not prepare, Your Lordship. Any other date, Your Lordship.
Hearing.
Lord. Deep, Your Lordship.
The number 45.
May I please, Lordship?
There is another PIL pending before this court.
Lordship.
On that railway.
Lordship, there's, I asked, last occasion, I asked to produce the record, but that record, CSR record has already been annexed to the writ petition. That has not been disputed by us. So that may not be necessary, Lordship. Here are the allegations that CSR report has not been complied, certain provision, Lordship. That was the allegation. And his representation is of 2014, Lordship. Thereafter, he did not file any press representation. Then there is a provision, Lordship, under section 22, subsection 3, Lordship. The central government, after consideration, the report may ask for certain, thereafter modification, they can issue the certificate. That has been given, Lordship. The sanction has been given, Lordship will find.
At 345. Both. 28, 345. Thank you. Right. Before a bench.
The number 49.
We have preferred a review against the order of 2013, my lord.
Quite a daring attempt.
2013, we have explained delay because we were not aware. We were the respondent on the other side. Normally here what happens, my lord, is a copy is not being served to the private respondent. Government, my lord, there was some writ petition which was filed, just a short, my lord. Writ petition was filed by some unsuccessful candidates who were the assistant inspector of school. There is a rule, Rule 8 of the Education Service Rule, where it says the assistant inspector of school, you requires B.Ed and B.T. For inspector of school, B.Ed, B.T. is not required. So the learned division bench, when this was put to challenge, said that what we'll do, giving a direction that opinion expert committee should be constituted. Now, expert committee was constituted in person's order, and they have justified why this rule is not bad. They have justified. Again, my lord, they came up before this normal court. Now the order, my lord, this was stacked together and there was some interim order not to finalize any fresh appointment. Now the inspector of school comes to the court and said that anyhow this is not connected with inspector of school. The court heard this matter, modified the order saying that they could go ahead with the appointment so far as the inspector of school is concerned. So the appointment was made. Thereafter, some unsuccessful candidate has filed a writ petition before this court challenging the appointments orders
Of the
of
inspector,
the inspector of school. These were pending. Now, when I appeared, then I found that is a stumbling block because there kindly see why we came for a review, my lord, at page 136. 136 is 26, 2013. Your lordship, the division bench has passed an order. Considering the challenge the writ petitioner proposed, lordship got it, my lord, is to propose appointment to the post of inspector of school out of candidate who do not possess BT, BEd degree, which qualification required for lower post in department. Matter was considered earlier and time was given respondent to consider matter. Accordingly, an affidavit dated 6/6/2013 has been filed, which in substance accepts the stand of the petitioner. In view of the stand taken by so and so by the commissioner, so and so department BT, BEd degree is necessary for the post of inspector of school. That's what with greatest respect before division bench. If your lordship kindly see the
properly represented you, the very case was that the qualification of BTPED is required only for assistant inspector.
and now that were the affidavit of the commissioner was there. I think it was overlooked. My great respect, my lord, kindly see at page 126.
There is the affidavit, can we have a look at it?
Yes, my lord, 126, my lord. 126 is the affidavit filed in which pursuant to that it was disposed of 6/6/2000 by the commissioner and secretary. Kindly see paragraph 4, my lord, that the additional affidavit is filed in compliance with honorable court's order passed in opposite writ petition. Deponent begs to have for the cadre of district elementary education officer, inspector of school, deputy inspector, requirement qualification second class, master degree having uniform brilliant career and possessing teaching experience school and college for 10 years or administrative experience for at least 10 years, of which 5 years must be in teaching. As per rule,
Hold on. Assistant inspector post must be direct recruitment.
it's a direct recruitment.
These are
my lord.
promotion.
Inspector of school also, it's a direct and promotion also.
So even for directly.
Yes, it's a,
qualification,
no, BA, BT is not required. I think,
that
my
is
lord,
an
that's
apparent
my,
anomaly.
my feeling is that, my lord,
For direct recruitees, you can't
my lord,
have that distinction.
yes, my feeling is also that when I have looked into it, because there is some sort of, but there is an affidavit which has been filed, rule 8 is today also it stands. How they describe, my lord, kindly see at page 128, my lord, 128. Paragraph 7. Paragraph 7. That a deponent begs to say duties and function, now they describe. Assistant inspectors are similar to that of deputy inspector of school, block elementary education. The assistant inspector are the inspecting officer in respect of the school under secondary education, while the deputy inspector of school, block elementary education are the inspecting officer in respect of the school under elementary education. In view of the above facts and circumstances, government is of the view, since the BEd BT degree essential for any officer having inspecting duties, the essentiality of BT degree in cadre of so and so as prescribed does not appear to be unjustified. So, but while disposing the matter, the word inspector of school, they pointed out that assistant inspector, they pointed out inspector of school, my lord. This is, my lord, what I found this is stumbling block for us. This will remain.
But otherwise.
But otherwise, my lord, this is.
You need to tell the state to reconsider this thing.
A state,
At least.
state. I am for this side. I appeared for the state, but here. A rule, my lord, they have,
Apparent anomaly.
they have
For
to,
direct recruitment, you can't have a lower qualification for a higher post.
they have to amend this rule.
Because experience, if you consider for
Correct, correct.
promotion, that's
That's
a
right.
different thing.
My already we join and we are enjoying that. That's absolutely no problem. But I think, my lord, this rule 8, it stands today. They have to come. If they want, the uniformity should be maintained. So a direct recruitment, they should amend this, my lord. But this I just wanted a review of this order. Apparently, it will be difficult before a single judge, my lord.
Is the rule under challenge?
This rule is, my lord.
Because
The rule, yes. Rule 8, yes.
Clarification.
Yes.
In this review, you are simply seeking a clarification.
Yes, correct.
Nothing beyond that.
Right.
But what about the position of the rule?
My lord, rule is what challenged, I noted, rule 8 in second writ petition 4433 of 2012.
At page 45.
Yes.
Is that still pending?
That has been disposed already.
Rule stands as it is.
As it is, that's the whole fact.
Then we have the order of disposal of that.
4-4, my lord.
Yes.
4-4. I think. 4-4. How can it be? How can it be changed? I had to change the one. Etc. There is a notification by the government of 2017.
Yes.
Which goes to show that in pursuance of the order dated 7/12/2016 passed by the Honorable High Court in 6907 of 2016 and pending amendment of the Assam Education Service Rules 1982. In addition to other qualifications as stipulated under relevant rules of the Assam Education Service Rules 1982, the candidate for the post of amalgamated cadre of Inspector of Schools, District Elementary Education Officers, and Deputy Director of Education should have BT/BEd degree from NCT recognized institution. When this was passed?
2017. So
11
now,
January 2017.
now that order has been ratified by this notification. We
That-
need any review. We can observe that in view of the subsequent notification, qualification of BT/BEd is necessary.
But I have to go through that also. I
Please have a look at it.
Yes. My lord, your lordship wanted to see that order also.
Yes.
That is 102. Page 102, 103.
But
That's
now,
all.
now I don't.
Now I
that
think, my
exciting.
lord, yes, I have to look into it. My order. Yes, he has gone now. From the other. Let me look into it, my lord.
We'll
People
have
have
it
a,
again on Wednesday,
my lord, wait, coming Wednesday, my lord.
coming Wednesday.
Yes. Because I'll be out of the Mizoram only tomorrow,
First.
that's right.
So when do we want?
Let's, next week, any date, my.
Next week,
Next week,
that's what we are saying.
yeah,
Next week,
Wednesday, yes.
Wednesday.
No. Let me go through it, my lord, let me find, it will have a ramification on this entire.
Yes, yes.
What a-
As grade list on, as jointly grade list on first March.
First month. And a copy.
Letter number 50.
This case, lordship, the petitioner wants a direction to modify that place of birth, lordship. I have taken it up with the minister. Multiple ministries are involved here. I'm seeking some more time. It can be after the holy.
Does not look good.
No,
One
that
of
is,
the guard the of this court.
yes,
Is
lordship.
required to approve.
Yes, lordship.
So please
If it
convey
can
to
be.
your officer that this needs to be done in a sensitive manner.
That will take some time, lordship, some discussion.
How much time?
If it can be after the holy lordship. Care of Mr. That lordship is fixing a date. Or 4 weeks. Lordship.
11th.
Lordship.
Letter number 51.
May it please the Lord. Well, this is an intra-court appeal. It is otherwise ready for disposal, hearing. Well, the issue relates to the filling up the post of the headmaster of the school on in-charge basis. Very temporary arrangement. In-charge headmaster was appointed. My client was appointed as the in-charge headmaster. That has been put to challenge by the private respondent 4. And the learned single judge interfered with, holding first that the seniority was decided in my favor, although that was not put to challenge. The seniority issue was settled. That was not. Who is appearing for respondent number 5?
Ready for disposal?
Yes, Lordship. Otherwise, Lordship, the rule says, Lordship, or even for insertship or for regular appointment, the requirement of the rule is that 10 years of minimum qualifying service as a graduate teacher, number one. Secondly, candidates should possess the PTBA degree. Here in the instant case, both the petitioner as well as the respondent, they are not fulfilled both the criteria. So accordingly, this honorable court directed to make a fresh determination of the seniority. Now, while determining the seniority by order dated 2017-2021, they hold that the appellant is the senior most teacher. But here, what happened? The school in question is provincialized with effect from 1/1/2013. So therefore, they became the government employee with effect from 1/1/2013. And they born in the cadre of graduate teacher with effect from 1/1/2013. But the rule of 24/7 says, if the date of joining of the cadre is same, then the date of birth is to be accounted. Now, by considering the date of birth, I am the senior most teacher, Lordship. That is why the honorable single judge directed or hold that the petitioner is the senior most teacher. So accordingly, direction is given to the director of secondary to for determination of fresh seniority list. Number one. Secondly, on the basis of the seniority, they should depute the teachers for pursuing BA degree. Until the arrangement, Lordship, is made, the inspector of school is directed to hold the charge. So I think my submission, Lordship, that there is no infirmity against this order, Lordship, because the rule is settled, rule 24/7. It is quoted. Lordship, may kindly see page 59. Page 59 for a moment, Lord.
Should I place my case? This is my appeal.
Page 59, Lordship.
I'm coming to it, my lord.
Lordship,
The
down
whole
below.
issue, my lord, my responsible submission, the learned single has misconstrued the entire. Firstly, this is a temporary arrangement. Fact remains that as per the qualification required to hold the post of or to get promotion to the post of headmaster, none of us possess it. The comment is that B.Ed degree is a must. None of us possess it. Now, the authority appointed me as the in-charge headmaster on the basis of seniority. That seniority issue was settled by the government on the appeal made by him. And the seniority issue was not taken in challenge, directly telling that order, that this order passed by the authority fixing seniority, my position below me, he never put it to challenge. Indirectly, he came in challenging only the appointment, my appointment as in charge headmaster. Therefore, the first ground is, what is the substantial right of the petitioner which has been infringed? When prima facie, the seniority has been fixed and my position is above her. On the basis of seniority only, because there is none qualified in the school to hold the post on senior on regular basis.
Substantial basis.
Substantial basis. Therefore, it is a temporary arrangement. I was given until post is filled up regularly on the basis of seniority. Now, how the question has been considered, Lordship will come to it. I will take your Lordships to the impugn order. Firstly, before that, Lordship may like to peruse at page 55. Our date of joining, page 55, Ballot. This was our initial date of, firstly, Lordship will kindly.
Can we have a look at the prayer in the petition, please?
Yes. Prayer in the writ petition, Lordship will find.
Page 34.
34 of the, the paper book.
Fresh gradation list, that is the prayer.
Yes.
They have challenged the seniority list.
Impugned order dated so and so. This is firstly, firstly, that is 27/10/2021 is the appointment order to the post of headmaster as in charge basis.
Second prayer takes
Then
care
second
of the
prayer,
petition.
publish a fresh gradation list.
Yes, that is the seniority list.
The seniority list was published on the basis of an order issued after adjudicating his appeal. That order ought to have been put into challenge. What is the ground on which that appeal was decided, fixing my seniority above her?
Have you placed the order on record?
That has not come.
Even you have not placed it on.
No,
This is an oral
I am
submission
not given that.
That there was any such order.
Kindly see at page, it is mentioned there. In the order to put bill, this appointment order. Yes, at page 49. Page 49, that was the impugn order. Here, it finds a mention. Lordship got it, my lord, page 49. Consequent, I am placing it. Consequent upon demise of so-and-so, headmaster of Rampur Salaipatar Sahad Ali High School, district so-and-so, and pending of claim of seniority raised by Mafida Khatun, the respondent.
Pending claim of seniority. When
Sorry?
was it decided?
Yes, second para. It is coming, my lord. So-and-so, the inspector of school was allowed to act as in charge headmaster of the school, Vide office number so-and-so, dated 22/2021. Now, then see. Now, government Vide letter number so-and-so, dated 21/10/22, were declared Wazuddin, me, Hindi teacher of the so-so school, as senior to Bopida Khatun, assistant teacher of the same school. So this was the order 21/10/2021. And then it says, accordingly, in pursuance of the government letter dated such and such 21/10/2021, and until further order, Wazuddin BA, Hindi teacher of Rampur Salapata Sahar Ali High School, district Nagaon, is allowed to hold the charge of headmaster in charge the same school, along with financial power to draw and disburse the salary, etc. of the staff of the school. Vice Inspector of School, Nagaon, relieved. That is my order.
Rule. The date of the order. That is not clear.
This order of 27th October refers to some determination, but where is the order determining the interested seniority?
That was never placed. That was not.
No, but do you have that order?
I do not have. We do not have that order.
Is there any such order?
That order is not with me. That
was not challenged.
Yes.
How can you question the seniority of this man?
This is the decision taken by the government lordship. So in view of that 21/10/2021.
You have a right to represent against the determination of seniority. If that is illegal, there is a challenge. It is required of you to challenge it as per law. That was never challenged. It may be wrong.
Yes.
That's a different thing. But without the determination of seniority being challenged in the writ petition or otherwise, how can we intervene in that?
If you look at the day, came to a conclusion that the petitioner, the appellant is the senior most teacher. But here, lordship, by counting the date of joining.
I don't know, sir, what is the consideration by which the seniority list was decided. That should have been brought on record. If you're not satisfied, you have to challenge it.
But
yeah. I am told that there is an Assam services appellate tribunal. Like
Administrative tribunal is there.
Administrative tribunal. So if at all you are agreed by the seniority list, you have to challenge that before the tribunal.
so that seniority list lordship never published lordship. Lordship kindly see.
That order is referred to in your impugn order.
Yes.
You should have got a copy. What prevented you from doing so?
Not the authority lordship, they can produce that particular order.
Why should we ask them to collect evidence for you? It is your client who is agreed by the seniority list. You can simply seek it under RTI if it is not provided otherwise. Yes, otherwise also, sir, the order is depriving you, both of you, from the post. So why is it required to be challenged? The order is justified. The
No,
inspector.
my lord, there lies the question, my lord. Since was already a finding recorded by the appropriate
We
authority.
can only observe that the finding regarding the seniority may be ignored, but otherwise the remaining part of the order is justified.
Now,
Because you are not qualified to hold.
no, my lord, then in that case, as because my respectful submission would be, then who will hold the post? Either one should be appointed.
Inspector holds it. Let the government decide.
No, my lord, then
who is to
whether,
assign the post of headmaster.
my lord, so until
The government does not want an unqualified person
true, my
to
lord.
hold the post of headmaster.
Technically, yes.
Yes.
Technically, yes. But Lordship will see the other part. So for the interest of the public institution is concerned, that will not be served by the technicality.
No,
That
they
is my
take
submission.
care of the things. They will appoint a duly qualified person as headmaster.
As early as possible. If they do it, it is good. But till then, someone who is responsible in the school, and I did the senior most person declared as such.
But both of you don't meet the
But
eligibility.
true, well,
norm.
therefore I am not claiming it on regular basis. I was given, the government has thought it in their wisdom
Other
that
than
someone in the school.
status, do you have any, other than simple status, do you have any monetary advantage?
Nothing. But then I am interested in the school management because this is my school. Someone from outside coming temporarily.
Mr. Government Council, take instructions, how long will it take for you to appoint a qualified person as the headmaster?
Part of the. To take the stuff of the out. Some is pure. Otherwise, that also is prior to appointing him as the in charge, the inspector was still holding the.
Yes.
And it was the order that the inspector now continues to hold the. There should be no difficulty. Because the fiscal power is held by the. While the academic matters are being kept to one of the senior most.
No, my lord.
Mr. Majumdar, but is the inter-se seniority between the appellant and the private respondent settled? I don't think, we don't think. No, the learned civil judges said to reconsider this.
The inspector of school holds the power, holds the charge of the master with powers under 49C plan the daily effect. Academic matters are looked after by either that is how the routine is.
That's right.
No, my lord, let my learned friend look
a
into
minute.
the order.
Just a minute. There is already a order of this court, number of orders, where it has been laid down that even for a temporary appointment, the government will have to follow the norms of seniority.
Yeah.
As on date, there is no clarity as to between both of you who is the senior. Moreover, neither of you meet the qualification.
Same judgment by law says that the most qualified person who has been given other than cannot be given the charge.
Where is that judgment?
The Jagannath Pegumelo that.
My lord, I will come to it later on, but let the facts be clear first. Let the facts be clear first.
At 2 p.m.
Item number 51 to continue.
Okay, putting to-
The judgment I have, the judgment I have given, my lord, that it is.
I will come to this judgment, my lord, in my school submission little later. Before that, Lordship will kindly find out what are the background facts for how I was appointed. That your Lordship will see. That decision is there. I will address your Lordship on that also. Because every case has to be decided on its own fact. So for the principle of law is concerned, yes, it is there. Now, the
We'll speak out our mind then. The best we can do is that we can make an observation that the findings in the impugn order regarding seniority, they will be ignored and the parties will be left to approach the appropriate forum for settling that issue. Otherwise, the direction is perfectly in accordance with law.
my lord, before that, I am grateful to your Lordship for expressing the mind. But before that, probably I will have to point out few things for little more time. And then I will request your Lordship to consider it, whether your Lordship's view needs to be reconsidered.
Definitely,
Yeah.
we are open
I am
till
grateful.
the last moment.
I am grateful, my lord. My lord, so far, the basic fact that we do not have the qualification, that is true. But seniority has been decided in my favor. That is as on date. That is decided.
Apparently erroneously.
No,
There is
my
an
lord, that we
apparent
do not
error.
know. That we do not know because we have no, that order was not put to challenge.
Criterion is settled that where there are two persons who join service on the same day, the seniority has to be decided with reference to the date of birth.
Well, provided it is on the same date. Here, that is not applicable. That is my case, my lord. Law speaks otherwise. That is why my ground is that 24/7 has not been properly appreciated. That is why I will come to it a little later. Lordship will kindly see at page 47. It is the inspector of schools who requested the authority to appoint one of the senior teachers of the school as in charge principal headmaster. On that request, because he was holding the search, he found it difficult to manage from a distance of 19-20 kilometers away from the school at page 47.
Sir, come to page 45.
45 is the seniority list prepared. It was forwarded to the government. That was put to challenge. It was taken on appeal before the government. Government has ultimately decided.
Who says so, sir?
That order says.
Show that this was challenged in appeal.
Well, that was in order. That has been mentioned in the order itself. That is what I'm
all
saying.
In the realm of uncertainty. We don't even know that there is an appeal.
No, that is why my case is. Well, it ought to have been put to challenge by them first. Because when the seniority was settled.
We are seized of the situation that two persons who join service on the same day.
No, my lord, we are not on the same day. Here,
How do you dispute this order in Annexure 4, please?
Annexure
Can you
4,
find any counter affidavit against that?
Annexure 4, this is, my lord, here it is date of receiving graduate skill and date of joining is different. At page 45, Lordship has referred to. Kindly see. My date is 18/10/93. Towards right hand column, my lord, second from right. And her date of joining 3/10/94. 3/10/94. And here in such a case, because there were two things, my lord. Pre-provincialized schools and recruitment after provincialization. Then two things comes. Here we were provincialized on the basis of our original seniority in the school. We carry that seniority. 24/7 rules, it speaks about the post recruitments made after provincialization. Then only the question of joining. Here, that is why I pointed out initially, my lord, that in that order, our same thing Lordship will find at page 55 also. 55. This was our appointment approved by the inspector of schools initially when the school was under deficit granting stage, where our Date of appointment has been shown.
Is the government letter 21st of October 2021?
No, but no
It's
one
not
got
on
it on record.
Sorry, Malu.
This is their appointment.
That order has not been brought on record. That was not put to
What is
challenge.
there in that letter?
Sorry?
Was he? And
59. On the basis, sorry.
this that the joint maybe
On the
My lord,
and Mr. Deka, there are two aspects here. One is that the seniority, interest seniority between your client and the appellate. Apparently, it was decided by the order dated 21/10/2021.
yes,
That's what we find the mentioned in 49 orders as well as in the judgment of the learned Singhal.
exactly.
This 21/10/2021 is apparently declared that the appellant was senior.
Yes.
And we find that there are some materials to even support such a conclusion. The date of joining of appellant was 93, your client was 94.
With that,
Just Mr. Court. Now, you have not challenged this order, 21/10/2021. Correct.
Correct.
Therefore, why should we go into the question or any court go into the question of the seniority dispute between both the parties? This is one.
not even a prayer.
This is not the issue here. Secondly, both of you are not qualified to hold it. Therefore, in view of this judgment, the division bench has ruled that unless you are qualified, forget regular, even in charge.
Yes.
So therefore, what is wrong with giving the inspector the charge of the?
I am not against the inspector.
Lord.
I am against, I am agreeable, Lordship. I am
You
agreeable.
want that I should be,
Yes, I am
I should be
agreeable.
removed.
Lordship, so far,
Inspector should be brought in.
Best we can do for you is that we expunge these observations regarding seniority which have been made in impugn order and then allow the things to proceed accordingly.
My lord,
So that your seniority is maintained
Yes.
as per 21/10/2000.
Exactly. I'm grateful, my lord. Only thing Lordship will kindly take care of. My anxiety is the inspector himself expressed his view that
We are
we
not bothered.
want
We are not
someone
bothered,
else.
sir. We are not bothered.
Page
He has to
47.
discharge his duties as enjoined by law. So if he fails to do so, there will be another inspector to take his place.
My lord, that of
We
course,
will not allow, in view of this division bench judgment, your
Lord.
clients, neither your client nor the respondent can be allowed to hold the
my
post.
lord, at the same time, judicial pronouncements are also there. Lordship is aware that to meet certain situations, stopgap arrangement, those rules are not strictly
Exigencies
applied.
of the-
That is
exigencies
why.
so require.
Exigency request. Now kindly see, my lord, the inspector of schools, he stays far away. That is why he has detained that someone of the school should be given the charge.
Fiscal arrangement, the inspector will take care. Academic arrangement,
Now, my lord, here in this order, fiscal arrangement has also been made. I have been allowed to
that we will not allow.
financial
Because
power to draw in
you are
these
not
bars.
qualified. No. You
That
can't
is
be
there.
drawing authority.
My lord, that of course, it is the wisdom of the
What
authority.
is the anxiety for your client to be declared as the drawing authority
No,
without
my lord,
holding the
I
qualification?
did not ask for, the authority has given me that. I am only coming before your lordship.
That is apparently.
It is the
illegal
wisdom of the
judgment.
government. It is the wisdom of the government. Government decided. Now, government has not said that we have wrongly decided. Government has not said that. Government has not disputed it. That's who we made it. We made it at the request of the inspector of schools who expressed his
Any
inability.
order passed in ignorance of law as laid down by this court
My lord,
will be held to be invalid.
my lord, under certain exigencies, situations, the authority is to run the show. And in the best interest of the institution, they have to decide. My lord, my interest is the school.
There is a MC for this school.
MC is there. I act under them only. Well, the school has to be maintained, my lord. There is serious situations in the school. Inspector remains 20 kilometers away. He cannot oversee the thing. That is why he wrote back.
There was anyone was
Well, it's, sorry.
Mr. Majumdar, what is the solution to this? There is a division bench order,
My lord.
says even for in charge headmaster, one has to meet the eligibility.
Yes.
Now, do you have any other teacher in that school?
My lord, not,
No.
in that school, my lord, the list does not show anybody else is there, my lord. Now, in this case, my lord, the regular selection is held now at the district level. So
But as you said, that everything is stuck up in
my lord, not
litigation.
not for all the districts, my lord. Most of the districts are under
So
litigation.
that is the norm across the country.
That-
No selection process goes through without being scrutinized by the High Court, as if we are the recruiting authority.
But no selection. Nowadays, district-wise selection, district-wise transfer and appointment is made.
Even on the case immediately after this, my lord, the rules are under checking.
So as the departmental council, what is your suggestion?
My lord, let the inspector of school hold it for now.
But as land council says,
My lord,
inspector is posted 20 kilometers away.
my lord,
How does he supervise
Yeah,
effectively?
exactly.
my lord, in most of the schools where these type of the kind of disputes are there, the inspector holds the financial part. The rest, he gets a advice from the school managing committee as well from lordship. Anything goes wrong, it is an immediate visit, madam. And it is not only the inspector of school who is authorized to do so. They are the ADCs are empowered.
My lord, inspector of school is in charge of so many schools.
Sir, how do
This is
you
on
get out of
paper.
this judgment? Either you satisfy us that this has to be referred to a larger bench.
My lord,
Have you read this judgment?
my
Please
lord,
go through.
yes, my lord. It is very talking, huh?
There is hardly any
Yeah, I'm,
leeway in this judgment.
my lord, here, I am, here, all aspects were not considered in my report
So
submission.
then we would have to refer the controversy
That
to a
should be
larger bench.
in such situation, because so far, a situation of this nature is concerned. How to manage? Fact remains, my lord.
There is a stopgap arrangement. The
Stopgap
inspector will take
arrangement.
care of things.
One ad hoc cannot be replaced by another ad hoc. And here, kindly see the practical aspect. My lord, otherwise, I have nothing to say. The authority itself decided that the school should be, and in fact, my lord, if a person, the senior most one in the school, if he can be entrusted, he will definitely take most. And
The order was- Can you point out any instance of any discrepancy after the direction given by the
My
in the
lord,
performance of duties by the inspector?
my lord, yes, my lord, in my response submission, in here, firstly, the learned single just committed the wrong because it went totally on.
Forget about that seniority part. Sir.
That
We'll
is-
make the
that was
necessary
the-
observation.
that was
We'll
the
make the
influence.
necessary observation.
Yes,
But so far as your apprehension
yes,
that the inspector would not be able to discharge the duties as required,
yes.
whether there is any such incident to suggest that he is not able to
My lord,
perform the duties properly.
his inspector's letter at page 47, that itself is suggestive of the fact that he is not in a position to. do it.
Then they will be required to post
No, he was,
more efficient person on the
my lord,
post of the
my lord, if there is someone, I cannot oppose to it. I cannot oppose to it. But when the inspector himself
So
says,
he simply say that you are required to post someone. He doesn't
yes,
say that I am not in a
at-
position.
no, at that time he was holding the post.
No, it is the duty of the
He
inspector of
was,
school lordship. Once
he
the
was
person-
holding the post that time as has been submitted by the London State Council.
He simply presents the situation to the concerned authority saying that you are required to post a headmaster.
Yes,
That's all. He
true, my
doesn't
lord,
say
that is,
I'll not be
what is
able
the,
to, I'll not be able to do the work
my
in
lord,
a
in
stopgap arrangement.
those words are specific terms not there. But otherwise he was holding the post. Why would have he
So
written?
we will simply make an observation that the findings so far as seniority are concerned,
Yes,
they will be expunged. Otherwise, they understand.
my lord, my response submission is, my lord, to that extent, only my anxiety lordship will can take into account. When the inspector himself says that someone is required to be
Your
appointed.
letter does not take you anywhere. Thank you. Dispose of.
So may I submit what you like? With regard to page 45, for one moment.
Lordship,
Page
may, just a
45.
minute. My lord, lordship
No,
may
that
do,
seniority list was not in place.
No,
yes,
We are not making
what I am
any
submitting.
observation at all.
No.
lordship
On the
may,
contrary, if you take our observation, date of joining of the appellant is earlier.
lordship may kindly mention one thing, if lordship finds it proper. Let the school be managed by someone, the senior most one in the school. Financial power can be handled by the
Still, that's
inspector.
not
of school.
determine
That is
who is
what the
senior.
government council is saying.
Yes, that can be done, my
That
lord.
is determined, sir. You have not challenged it.
No, my lord. I have been
No,
given the power
he
now.
says that seniority has not been determined. He is
Yes.
wrong in that.
He is wrong, he is wrong.
He is
Therefore, I
absolutely
say,
wrong.
my lord, the inspector of schools wanted only the senior most someone in the school.
Let the inspector decide how the academic things are to be carried forward. We'll leave him at liberty, but financial powers will be exercised by him.
Well, that lordship may make clear, but I have no objection to this. But I wanted the administration in the school should not. Administration in the school should not suffer. That is my anxiety, my lord. Because students are there, everything will go helter-skelter there.
Very well.
I'm deeply
It has
grateful.
created a logjam.
Yes, that is happening, my lord. There are instances.
Lordship, liberty may also be granted to me, Lordship, to challenge this particular order, Lord, 2110 to
It is, we have not taken away your right.
that
There is a
liberty.
tribunal constituted for that.
No,
purpose.
it should be before the director
Find
because,
that
because the rule says,
the rule of statutory remedy being followed is being flouted right, left, and center in this court. At least we will not allow that.
True.
There is a statutory remedy, you have to approach that.
Order, the principles of order to rule to might come in your way, mistake. You have not taken that. You are the petitioner.
Yes. Deeply obliged.
Letter number 52.
obliged.
May it please your lordship. Lordship, as per office note 16/2/23, your lordship, affidavit in respect of dusty service is not placed on record, your lordship, but we have filed the affidavit on 17/2, your lordship.
On 17.
Yes, sir. Respondent number 1.
Call for the affidavit of the. Take to have been filed on
17/2/23.
the matter.
Letter number 53.
Please, your lordship. My lord, here we have challenged the order of the honorable single judge dated 5/10/2021, my lord, at page 41 to 46. This is regarding settlement of fishery, my lord. The fishery settlement of fishery was made in favor of the writ petitioner, my lord. And they have challenged on the ground that it is a 60% fishery.
The appeal has been restored.
Yes, my lord. So, my ground is that, my lord, the appellant, my lord, has no locus standi, my lord, because the appellant has never, my lord, participated. The appellant has never participated in the tender process. The writ petitioner had participated in the tender process, and the tender was made settlement. I am for the writ petitioner. That is, yes, my lord. I have filed the appeal, my lord.
If you say
I'm
that the
for
appellant
the-
has no locus
sorry.
standi, to
Sorry,
make
ma-
things easy for us.
Sorry, my lord. I am the appellant here.
Maybe. My learned brother says that maybe you are stating the truth.
My lord, the private respondent, my lord, in the writ petitioner, his stand was that it was 60% fishery.
They're appearing for the state.
Yes, I am appearing for the state lordship. Yesterday evening, we have received an instruction lordship, which the lordship supporting the stand of the appellant itself lordship. This is our instruction.
Government is supporting this.
Lordship as this instruction that we received lordship. And in the writ petition lordship, actually, we are not been able to file our affidavit also lordship. So if we maybe,
now, do it
yes,
now,
lord,
and we put the private party notice.
yes, lordship. That-
And the IA is for stay, my lord.
Black. Black.
The number 54.
Now, item number 54, 55, 57, 57, 58, 59 of the same rank and 65 in it. Of similar matter, Lordship provided that the municipality board should take steps by Dusty. That we have failed, my lord. We need some more time. 10 days, my lord, let it come in the first week. And matter is at a very, in the short campus, whether the direction of the honorable court for giving settlement for 8 months is correct. Beyond, that is the beyond the period of settlement given in the annex. Otherwise, I am not challenging the order by which the settlement was satisfied. Beyond 31/3/2008. Another 10 days may be given so that your lordship fixes the matter on first week of March. It can be sorted out. Otherwise, it's an important question of law, my lord. If your lordship knows, my lord.
Respond number one.
Yes, other private respondents also. Yes, I am for the appellant.
That's right. Justice steps on whom?
In other cases, all private respondents.
Private.
In some cases, one, some cases 4, 5.
Give your, give your answer. Give your.
Yes. That's the correct. It will come in the first week, my lord. 65 also, same.
We can have it in the third week of March. Third week of March.
My lord, 13. Item C, my third of March.
Third week of March.
My lord, 31st is the last day.
30 commences from 13th of March.
13.
Second week is virtually holidays. So we can have it either on 13th or 14th March.
13.
13th March.
Yeah. Item 65 also same, madam. Apply.
Item number 64 of supplementary list for orders.
What happened to 20? Two.
Lordship, kindly pass over the matter for the day.
Service is complete on the.
Service is complete, ma'am.
Lordship, can it be fixed for admission on?
Item number 60 and 61 of daily list for hearing.
Partner? Only these matters are properly shall be put by the bench of
Any date after 9th, madam.
after 9 on. We are virtually forcing our hand to continue the roster after 9.
Madam.
14.
Okay, thank you. Okay.
Item number 62.
Is that matter wherein we had called for the service record?
I was, is this a case of habeas corpus?
No. The earlier matter is that case wherein we had called for the service record. Okay. It's okay. Is the same matter wherein we had called for the service record of the mother?
Yes, madam. They have been directed, my lord.
Okay. Very well. Habeas corpus. Detention under.
Madam, this is a PIT NDPS, madam, prevention of illegal. My lord.
Okay.
Madam, that your,
68.
yes, my lord, that your lordship will find that order, my lord, at page, my lord, 17.
Once
17, my lord. Page 7, 1. My lord, the contention before the learned single judge was that, my lord, the detention order was passed.
you are reading at page number
Page number 17, my lord.
once.
17, that is the detention order, my lord.
Yeah.
For the very first paragraph, my lord, whereas a police report and connected records have been laid down by the undersigned by the Inspector General so and so, my lord. My lord, this police report and the connected records were not supplied to me. Number one ground. my
Just
lord.
hold on.
Right.
You are reading at Page number 17 of the impugned order.
Yes, my, no, the order, yes, my lord, impugned order.
Yeah.
Whereas a police report and connected records have been laid before the undersigned by the Inspector General of Police, Assam, Moaigaon, by this letter number so and so. While passing this detention order, my lord,
You're reading it. Which paragraph?
first paragraph, my lord, annexure 1, page 17, my lord.
Copy of the detention order you are talking for.
Yes, my lord.
Yes.
My lord, this detention
Documents relied upon, not supplied.
not supplied. That is number one ground, my lord.
Just hold on.
My lord.
Yes, this is the first ground.
First
Then-
ground, my lord, I have narrated the grounds, my lord, at page 11, my lord. Unless my second ground is that, my lord, the detaining authority should place my representation before the advisory board within a stipulated period as prescribed.
That is been held to be directory by Supreme Court in number
Yes.
of cases.
Yes, my lord. And as per section 9 of the PITPS and NDPS Act.
Yes.
Secondly, my lord, the advisory board should consider, should give its opinion
Whether
within a.
this man was in custody when the order was passed,
Yes, my lord.
just hold on. Where does the detaining authority deal with the suspect?
My lord, the detaining authority, my lord, during the pendency of the case, my lord, my representation, they have disposed of mechanically.
So this fact was required to be considered in the detention order itself.
Yes, my
That
lord.
the detainee is in custody and
Yes.
there is a likelihood of his release.
Yes.
N. Mirarani, that is the judgment. Yes, all right, carry on, sir.
My lord, then, my lord, the advisory board should should give its opinion within a period of 7 weeks as prescribed under section 9 of the Act, my lord.
Right.
In the instant case, my lord, it has been beyond that time, my lord. And the honorable single judge court, my lord, while considering this contention, my lord, has held, my lord, lordship will find that at page 100 onwards, my lord.
100.
Page 100. Page
Then you have
100,
taken a ground.
my
And
lord,
the fact that the detainee was in custody
my lord,
in connection with the criminal case, and this satisfaction has not been recorded,
my
that he is likely to be released on bail. Whether you have taken this ground.
my lord, in fact, the 7 cases against which are pending against me, in all 7 cases, my lord, it is of a small category under NDPS
So
Act.
he must have been released on bail.
Yes, my lord.
Okay.
All the cases have been granted bail by this honorable court, my lord.
Very well, very well.
My lord, now page 100, my lord, paragraph 30, my lord, 32.
Yes.
My lord, during hearing, D. Nat, learned senior advocate appearing for the state, submitted as per requirement of section 9 of the Act, read with Article 22 of the Constitution of India, a reference of the detention order was made to the advisory board for consideration, and accordingly by a notification dated so and so, the government reconstitute the board under the chairmanship of a retired judge and 2 other members under section 9A. Mr. Nat further submitted the advisory board by its report dated 14/6/22 renders its opinion, holding the unanimous opinion there was sufficient ground for detention of Shahrukh Ahmed, the petitioner, my lord. Now your lordship will come to below, my lord, 34, my lord, paragraph 34. The aforesaid opinion of the advisory board, it is noticed, was rendered within 12 weeks, 6 days, which is marginally beyond the period of 11 weeks as required under section 9C. Admittedly, my lord.
Let's have it and NDPS. Yes, Mr. Counsel, what do you have to say?
There
This
is,
approach of the learned criminal judge is hypertechnical. Supreme Court says
Madam.
that a detainee is entitled to send a postcard saying that my detention is illegal. He can take whatever grounds are available to him under the sky when the order is under chilling.
Madam.
2 to 6 in habeas corpus is not restricted by pleadings.
my lord,
This is mandatory.
my lord. On the last occasion, this question was raised by my learned friend.
Yes.
Then we were asked to file an affidavit.
Lordship may kindly see the
This is
additional.
an admitted position.
My lord, there is a,
Beyond the statutory period.
my lord, there is a reason, that reason we have explained here. Lordship may kindly see, because the
Is it
board,
Limitation Act applies to these proceedings.
I'm not taking that. My lord, the board was not there for some time because of the expiry of one of the members of the board.
That is your problem.
And the board was reconstituted. This is a fact, my lord, I cannot dispute here.
Statute prescribes a straight jacket formula. Do these things within
Within
the
a
stipulated
time frame.
time, or else the proceedings are vitiated.
Correct.
Or all we may say, the detainee may have any kind of antecedent, but the detention has to be strictly in accordance. Is there any scope of escape?
Only one thing.
Any law?
Yes, my lord.
please?
My lord, I am relying, my lord, one of a high court judgment, my lord.
There's no question of substantive violation. Every violation in these cases is substantive. Howsoever slender it may be.
Right.
These are draconian laws. So the slightest mistake and the citadel fall.
My lord, last paragraph.
You will find n number of Supreme Court judgments.
Yes, well, I have, my lord, I have.
So
my lord.
why do you say
Well,
that
my
the
lord-
High Court judgment passed?
My lord, first, my lord, because on, it is specifically stated, my lord, merely on the,
Leonard Single, how does he deal with non-supply of documents?
my lord, it is silent, my lord, totally silent, my lord.
No, where have you raised the point? Where have you raised the issue?
Yes, I have raised the issue.
No, no, it's a single judge.
Yes, yes.
Sir, habeas corpus,
True.
supply of documents relied upon.
I'm only on the manner in which the almost single judges dealt with the matter. If the argument was made, then there will be something incorrect.
Is there no pleading in the?
Yes, my lord, specific pleading, my lord.
Please
My lord, one fact is that, my lord, to be very much honest, my lord, during the pendency of the writ petition, the learned government advocate then came up and said that your advisory board has passed this order. The learned single judge held that you have not challenged the advisory
It was
board.
not required to be done.
That's the
Where
case.
is the
my lord.
confirmation order? Was that?
No, no, my lord, as per confirmation order was not passed till date, my lord.
It was not passed.
Not
Then the
passed.
detention would lapse, sir.
Yes, my lord,
There's
that's
no question of the confirmation order not being passed.
not passed, my lord.
Oh, you are mistaken. We have the confirmation order, sir. The order was passed, initial order was 16th March.
Yes, yes.
The tenure has to be for 1 year.
1 year, maybe 1 year,
There is one fault, the basic fault in your initial order.
Right.
He can't direct detention for indefinite period.
It has
Look
been,
at that order.
it left us after 1 year. I mean.
The detaining authority is not empowered to pass the
Yes.
initial order for an indefinite period.
My-
Look at the order, please.
9F, my lord.
16 March,
16 March, page 17. Ma'am.
please. Until further order, which statute gives him the power to do so? It has to be until confirmed.
Until confirmed.
The order is liable to be set aside on more than one ground.
9F, my lord, of the PATA.
I don't know, sir, what kind of proceedings took place in the advisory board, but I had the good fortune
My lord,
of appearing in a board
my lord.
which was headed by Justice Y.K. Sabharwal. The other members were Honorable Justice D.K. Jain and Honorable Justice R.C. Lahoti. Even if a single line was said regarding documents not being supplied, the authorities would be shown the door. Right then and there. This is preposterous. You need to train your officers better.
My lord.
9F, confirm it.
Do you have the confirmation order with you, please?
Confirmed order was not.
We fail to understand.
My lord.
During entire proceeding of the writ petition, it has to be confirmed in 3 months.
My lord.
Where is that?
I don't confirm. If we,
The writ petition came to be filed when? On what date?
Past date, my lord, before this court, my lord, division bench.
Yes. What is the date of filing of the writ petition?
My date of filing was, my lord, 12/9/2022.
12/9. So you are not communicated with the confirmation order in the meantime?
No, my lord.
How can that be?
No, man. And in
Then there
fact,
is no confirmation how the detention is valid.
they have gone for attachment of my land and property.
That would follow under
My
68.
lord, 68, my lord, yes, my lord.
Probably you are fighting this writ petition only for that purpose.
And one,
We post tomorrow.
My lord,
We need the confirmation order.
my lord, I'll find out my difficulties, my lord, my learned colleague who was assisting me, today he's absent.
Pardon me for being so aggressive, but detention orders
my
for my forte, my practice.
law itself is like that. Strict interpretation of the rules of procedural safeguards. Article 20.
Tomorrow,
My lord.
we need the confirmation order.
My
If there is no confirmation order, the man could not have been continued in prison. And it had to be communicated. So why the council was not having confirmation. Tomorrow. That's on it.
My lord,
Take that. You know what happened in Rajasthan? There were many, before the borders were encumbered by wired fencing, there was a lot of cross-border smuggling from Pakistan. So there were many detention orders pertaining to narcotics, gold, all kinds of things. So there were large number of detention orders till 94. Thereafter, the things stopped. And that is why the authorities forgot the power of detention. So post 1994, the detention order, they were so cursory because the officers were not trained in that.
Yes.
But this is a detention by NDPS.
and
They are supposed to be, they have no work other than this.
regularly they are doing it. They should be aware of all the.
So we'll require that order to this tomorrow.
if any,
If any,
if any.
if any,
If any.
if any.
And if there is no order, then the authorities, the jail authorities, they will all be facing heavy costs.
I'll
Because
find out.
that then it would be a grossly illegal detention. Without confirmation of the detention, it would not be so. We are sure that the confirmation order must be there.
Yeah,
But then along with the fact that the order was passed, it has to be communicated.
communicate. Yeah,
So
after
both
confirm.
things, State Council record from the prison whether the order was communicated. Madam, who is for the prisons department?
Prison-
You are there? In which jail is the detained law?
Borpeta.
So we need that record also.
Sorry, madam, Pukraja.
We'll find.
Item number 6, count 2.
May I please, Lordship? Alert, in this case, our instruction was to withdraw the writ petition. But I have been told by my junior that they want some observation. In that case, we will argue on merit.
May beg your lordship.
What kind of observation will come?
My lord, the date for passing no confidence motion against the president was fixed on 31/2023, my lord. But 2 days prior to that, my lord, date, my lord, on 28/1/2000.
Secretary fell in.
No, my lord. That part is already over, my lord.
Okay.
Then we filed the petition before
During
this,
pendency of that petition.
my lord. No, my lord. Initially, my lord, we brought no confidence motion. And that date was fixed on 28/6/2022.
Yes.
And on that date, my secretary fell unconscious. So, my lord, this no confidence motion, my lord, could not be carried out.
Yes.
And no confidence motion was killed at that time, my lord. Then we approached, my lord, this honorable court by filing a writ petition, my lord. And the largest single judge, my lord, passed an order giving direction to all the official respondents to fix the date for passing no confidence motion.
Considering a fresh no conflicts.
My lord. Then, my lord, a date was fixed on 9/1.
Yes.
Due to some other reasons, my lord, the meeting could not be held on 9/1. Then the deputy commissioner of the district, my lord, fixed the date on 31/2000, my lord, 23 for passing the no confidence motion. But on 28/1, 2 days prior to the date of no confidence motion, the president tendered her resignation.
Then Deputy Commissioner said that as she has tendered resignation, so there is no necessity of passing of my lord, no confidence motion. Accordingly, yes,
No, thereafter, my lord,
thereafter something happened. Maybe. Yes, I'm completing. Then Deputy Commissioner, my lord, stopped the meeting, saying that as she has tendered her resignation, so there is no necessity of passing any no confidence motion.
Right.
But after 7 days, she very she cleverly would do her resignation letter.
So we give you liberty to file a fresh no confidence motion. What is
Yes,
the
yeah, that we also, they may file a fresh because,
No.
That date mechanism.
No confidence motion was moved by you.
no,
No,
by them.
by us, my lord. By all the ward members.
So then you move a fresh no confidence motion.
Yes.
if you so require.
Then your lordship may kindly fix the date, my lord.
No, there is,
No,
they have
that
to
you have
move.
to do before the panchayat.
Yes.
To do it, if you are still in a position to move it,
Yes, well, all
then
the
do it.
all
do
the
it.
10 members
What
out of 10.
stops you? The law doesn't prohibit you from moving afresh for the no confidence motion. We'll give you the liberty.
Yes.
Then,
It
my
is
lord,
more than 6 months have passed. So
Yes.
earlier has lost
There's
the.
left.
Left.
we
Yes.
apprehend, my lord, that earlier we brought the no confidence
There
motion.
will be horse trading. Let it be so.
No, my lord. All the 10 members out of 10 are still united, my lord.
So, all right, then what is the problem?
Problem
Move
is-
a fresh no confidence motion.
My lord,
We will observe that if any no confidence motion is brought, it will be taken to its logical conclusion within a stipulated period of time. That's what we can do.
then again, my lord, she may tender resignation before the no
Yes, she
confidence
may, that
No,
is
we can
apprehension.
say that it will be taken to the logical.
of that.
WPS number 497 whereby thereby I directed my meeting for the particular no conflict as proposed by the requisition dated 13/6/2020. From the submissions made to the part, it appears that due to the development the requisition dated 13/6/2020 at that the respondents have submitted that notwithstanding they are attached to a fresh requisition or expressing that for requesting holding the special meeting discuss the no conflict. Bring in a fresh no conflict against the appellant. In view of the without expecting any further close with by granting respondent to what no members without bringing a fresh conflict. If so, if such a motion is brought, follow it.
Number 13.
Published.
Present, even if the matter was called out twice, none present for the plaintiff. Dismissed for want of court.
There is a matter item 116, my lord. Actually, we are for the respondent, the state is the appellant. This matter is otherwise covered by division bench judgment.
You have to inform the state first.
We have informed, my lord.
You
Like,
have to
can I
ensure
make-
their presence also.
Can I make one prayer, my lord? Let this matter come on Friday in the regular,
Not on Friday, maybe
Monday,
in the next week.
Monday. my lord.
Let the matter be notified on the regular list on Tuesday. That is the hearing day, we presume.
There is a long tweet. Put it on first, my lord. 28, so
First.
many matters are fixed.
First. Hope that your concern of hearing matters not being taken up has been addressed.
No, my lord, what I felt was, my lord, we should, my lord.
We must. All of us must.
And my lord, because there was a time, my lord, this practice almost stopped. Therefore, people will that inertia is still going on. So hopefully my lord, things will improve.
Yeah, please.
Yes.
My lord, this review is against order dated, my lord, 1/11/2021, passed in WTC at edit appeal, my lord, 161 of 20, my lord.
Yes.
My lord, relevant page is, my lord, page 27, my lord. My lord, I am only drafting para 4 and 5 of the judgment, my lord. May I read, my lord?
Yes.
The order of the learned, para 4, my lord. The order of the learned single judge dated 26/9/19 has been challenged before this court in the present writ appeal. The only ground urged by the petition writ appellant for the grant of the benefit of the order dated 26/9/12 and for extension of his services for further period for further 5 years is based on the fact that petitioner writ appellant is also getting the same pay scale as is given to a professor. Therefore, he is liable to be given all the benefits which are given to a professor, including increase in the age of superannuation. Well, first, this was not the ground, my lord. Actually, my lord, our ground is basically, my lord, that the professor and, my lord, the principal of a college, my lord, they belong to the same grade, my lord. They belong to the same grade, my lord, and same academic level, my lord.
Right.
So, my lord, this is a, my lord, perhaps not in consonance with the, my lord, rules, my lord. Secondly, my lord, para 5, my lord. Para 5. We, however, do not agree with the said submission as pay scale is only one of the aspects relating to the post. Moreover, the admitted position is that at no point of time the petitioner appellant has worked as a professor or even as an associate professor.
Right.
He was initially appointed as a lecturer, now known as assistant professor. And in the capacity of an assistant professor, he was later appointed as principal of the college. We have also been shown by the Council for the State Government the qualification of principal of a provincial college, which are as under. Now, Lordship may see that A is eligibility and B is the tenor. So for eligibility concerned, I am qualified and accordingly I was appointed as the principal.
Right.
And the fact as noted by the
finding in the preceding para regarding you never your client never having worked as a professor or as an associate professor. How do you question that finding?
This finding is not correct because an assistant professor cannot be appointed as a principal.
No, simply because he was at some point of time appointed as the principal, maybe erroneously. That cannot give him a right to claim that post.
No, my lord, he was not appointed erroneously. My lord, when he, this finding is based on the when he joined the service, my lord. Admittedly, my lord, he joined as a lecturer, my lord, which is now known as an assistant professor, my lord. But subsequently, my lord, he obtained the qualification.
He may have obtained the qualification, but whether there has been a formal declaration of him being an associate professor or a professor.
My lord,
is there any such document on record?
My lord, that document is not there, but my lord, according to the state's own, my lord.
He may be holding the qualification,
my lord,
but whether any formal order was passed.
No, my lord, formal order was not passed, but my lord, impliedly, my lord, just have a look, my lord. Just have a look, my lord.
Yes, yes.
My lord, the eligibility, my lord, number 1, PhD degree, my lord. Number 2, my lord, professor / associate professor with a total service experience of at least 15 years of teaching research in university colleges. So, my lord, even assistant professor, my lord, cannot be appointed. And it was not their case. Then now let us come to B, my lord, tenor. In the same page, my lord, tenor. A college principal shall be appointed for a period of 5 years, extendable for another term of 5 years on the basis of performance assessment by a committee appointed by the university constituted as per these regulations. Now, 2. After the completion of his her term as principal, the incumbent shall join back his her parent organization with the designation as professor in the grade of the professor. Well, this is very important, my lord. My lord, once a person has been appointed as principal, my lord, so he can be appointed only for a period of 5 years, my lord, and it can be extended for further 5. So, my lord, total period is 10 years, my lord.
Right.
No, my lord, I was appointed as by in this college
on 1/1/2013, my lord. So by this condition,
By
my lord,
influx of time now,
my
what
lord,
survives?
yes, my lord. My lord, my lord, suppose my superannuation this estate had not come into picture, my lord, then I was entitled to, my lord, January 23.
Yes.
No, my lord, because of my superannuation and without extension, I was retired on, my lord, July 2019, my lord.
But there is no question of you continuing on the post
No,
beyond that period.
my lord, admitted. But my lord, if we take, my lord, lordship consider this rule, my lord, then I was to be reverted back to my position as a professor, my lord.
Beyond the date of superannuation.
No,
Then
no, my lord, if we take it in correct sense, my lord, I am my lord,
superannuated while holding the post of principal,
my lord.
there is no question of reverting you back to the original post.
No, my lord, this, if we consider this rule, my lord, then it, my lord, in my submission, my lord, it impliedly it means, my lord, that if I retired as a professor, because had it I have not been, my lord, then I was to be reverted back to my post, my lord, as professor, my lord.
Very well.
My lord, assuming that my age has not reached 60 years at that time, then I was to be appointed to reverted back to my post as professor, my lord.
Yes.
So,
now what is the grievance?
no, my grievance is, my lord, that in this is one aspect of the matter, my lord, that if we consider their own rules, then also, my lord, I was to be appointed, reverted back to my post as, my lord, professor in the professor grade. So, my lord, if professor grade, there is a rule of the state government has extended the limit.
Sir, whether your client was ever appointed as a professor?
No.
No. So as the situation boils down to the fact that your client was actually an assistant professor. He was appointed as a principal. He continued on the tenure till the age of superannuation. So when there was no appointment as a professor, why was he to be reverted to the position of professor on the date of superannuation?
No, my lord, so far the designation as professor or associate professor is concerned, my lord. This is the, my lord, the prerogative of the state government, my lord. In, my lord, most of the college, except, my lord, universities, hardly, my lord, they appoint any person.
We are not going on those ceremonies. This is
No,
the view.
my lord.
What is the error apparent on the face of the record?
No, my lord. My lord,
yeah, we are not hearing an appeal against that order.
No, certainly, my lord. But my lord, no, the honorable court has held that we have taken only one ground, my lord, that the salary of the pay was of the same, my lord. No, my lord, in another case, my lord, the state, my lord, policy decisions to be taken by the state government. There is no dispute about it.
Your only grievance is that your client should have been retired with a designation professor. That is the only grievance.
Yes, my lord, and
it's academic. Purely an academic exercise now.
No, my lord. If I am treated as professor, my lord, then
for that purpose you will have to show some communication order.
My
lord, he was given the designation of
my lord may have just a look, my lord. To my lord, writ appeal, my lord. Writ appeal, my lord. There is a.
God, by any chance, are you from Rajasthan?
My lord.
See, so your accent is very apparent.
My lord.
From Bhilwara?
I am from Ratnagad, my lord.
Ratnagad.
My lord.
Okay. Yes.
My lord, page 54 of my lord, writ appeal, my lord.
Yes, please.
My lord, this is page 54, my lord. Writ appeal.
Yeah.
My lord, this decision was communicated by my lord. Similar matter arose before the university, my lord. In university, there is a university.
We are not reopening the proceedings.
No,
A simple query to you.
My lord.
Any order whereby your client was appointed or even given the position of a professor or an associate.
No, that was certainly not, my lord.
So there is no question of reversion to that position.
But my lord, the principle is stated, my lord, as per their own, my lord, criteria. Principle is stated as professor grade, my lord. If I am
simply because the man was at certain point of time given the position of a principal, whether that could give an automatic consequence of him being treated to be a professor without there being a formal order.
But my lord, in another case, they have the,
So you are not on Article 14 here in review. Yes, Mr. Counsel.
Lordship, after going to the petition, Lordship, and the judgment passed by the Honorable Court, Lordship, there is no any error apparent in the law, and there is no any mistake, Lordship. So, Lordship, the first case, Lordship, the review petition which is preferred by the petitioner is not maintainable and liable to be dismissed.
Brother, what's your opinion?
Yes,
Brother
Lordship,
Shema.
Lordship, subject to your Lordship's decision, the petitioner was serving as assistant professor, and in that position, he was appointed as principal. He was never appointed as a professor. And the government policy says that it is only a professor of an educational institute, including medical college, who are entitled to 65 years of service. So maybe, Lordship, in my view, I think the learned counsel for the review has not make out a
We
case.
can close the matter saying that there is no error apparent on the face of the record in the review order.
I'll leave it to your Lordship.
Having heard and considered the submissions advanced at bar, and after going through the order under review dated so and so, comma, we find no merit in the contention of learned counsel for the review applicant. The order under review does not suffer from any error apparent on the face of the record. More particularly when, comma, it is the admitted case of the petitioner that he was never appointed as a professor, oblique associate professor in the respondent department. As a consequence, comma, there is no merit in this review petition, which is dismissed as such.
Matter number 2.
May it please your lordship. Lordship, only one aspect is under review here, your lordship. It's regarding the right of the employer to recover, your lordship. Admittedly, he was a grade C employee, your lordship, and as per
You are banking on
Rafiq Masih.
Rafiq Masih, sorry.
Yes, your lordship.
Yes.
Rafiq Masih, and
Whether
also
that was not considered.
that was not considered, your lordship. That was probably out of oversight. Discussion was there regarding entitlement as to the TA, but regarding recovery, there was no discussion, your lordship.
Brother,
Lordship.
regarding this recovery, Rafiq Masih would come to their aid. What do you say?
Yes, Lordship, I feel so.
Can we ask the government to respond?
Yes, Lordship.
Yes, Mr. Counsel.
my lord, at page 16, my lord, office memorandum, it is a Rafiq Masih case is quoted at para 2.
Yes.
And the issue has subsequently come up for consideration before the Honorable Supreme Court, the case of State of Punjab and others versus Rafiq Masih.
There is one more judgment after Rafiq Masih. It was explained.
Italian portion, my lord. Italian
Yes.
portion, my lord. Having examined a number of judgments rendered by this court, we are of the view that orders passed by the employer seeking recovery, monetary benefits wrongly extended to employees can only be interfered with in case where such recovery would result in a hardship of a nature which would be outside of the equitable balance of the employees, and in order to ascertain.
Hold on. What
Lordship,
precisely was the challenge in the petition?
writ petition, your lordship, it was the challenge, the order of the administrative tribunal was challenged, your lordship. Actually,
We will direct the tagging of the file. We'll like to look at the pleadings of the writ petition.
lordship,
Yes.
We'll get the file of the writ petition tagged, and then we'll consider it on a subsequent date. Is it okay? Is there? Okay.
lordship, I would suggest if they reply to that as well. Rafiq Masih.
Can we ask the government to submit their response, brother?
Okay, Lordship. Okay.
Well, the counsel for the respondents shall file a counter affidavit to the review petition within 2 weeks, list thereafter.
Much obliged.
Item number 3.
Item number 3 is also same, your lordship.
Same, 2 weeks. Same matter, brother.
Yes, Lordship, same matter.
Item number 4.
Union of India.
Lordship, this review petition has been prepared by the Union of India, Lordship. The order is at page 26, Lordship. What happened, Lordship, is herein the respondent, Lordship, was appointed as a constable in the CISF, Lordship. From a post earmarked as he should be a scheduled tribe candidate from the state of Arunachal Pradesh. Now, he submitted a caste certificate. When he sent it for verification, the DC stated that the Devris are not scheduled tribe from Arunachal Pradesh. So we draw a proceeding and removed him from service. Then single judge held that since that caste certificate has not been cancelled as per the Madhuri Patil's dictate, Lordship, so he asked for reinstatement with 50% back wages.
Okay.
That we put to a challenge in the writ appeal, and the writ appellate court agreed with the judgment of the single judge, but referred the matter to the state of Arunachal Pradesh to scrutinize his caste certificate. And finally, that has been held that he is not a state tribe.
does not have
That
the
we
status.
have filed an additional affidavit.
You are filing it today.
No, Lordship, it was for idea, Lordship. That must be first part of the record. I don't know
Okay,
whether.
Okay.
In which
The caste certificate has been cancelled.
cancel, Lordship.
So we'll have to put the respondent to notice.
Notice, Lordship. So that's why the back wages part only. We have reinstated him back, but the back wages part, Lordship,
Yes.
only.
But then if he is not having the caste certificate,
And he has put to challenge that in a separate writ petition.
what is the number? We'll tag it with that.
I will give the fundis the number.
Okay, sir, brother, we'll tag it with the writ petition which the respondent filed, challenging the cancellation of his caste certificate. That
Lordship,
must be before the SB.
A single bench, Lordship.
We can have it together in division bench, brother.
Lordship, as you please, Lordship.
I'll fund this to the benches. Court must.
The Learned Government Council states that that pursuant to the inquiry conducted following the directions given by the division bench, the scrutiny committee has passed an order dated 4/5/2022, cancelling the caste certificate of the respondent. It is further stated that the respondent has challenged the said order by filing writ petition number so and so. The registry shall tag the file of the said writ petition for joint consideration with this review petition after 2 weeks. So he will automatically be notified. Copy of the writ petition, counsel for the Union of India shall provide copy of the writ petition to counsel representing the respondent.
Review petition, Lordship.
Review petition, counsel representing the respondent in the writ petition. Number so and so.
Responded writ petitioner.
To the counsel representing the writ petitioner. Okay, very well. Thank you.